I able to get a loan on my personal injury case? This is a very common question that I get from clients, and it frankly just makes sense. Imagine an individual who has been hurt, who has incurred medical expenses, who's been unable to work, and who has other bills and the expenses of daily living piling up. It simply makes sense for that individual to inquire if they're able to get a loan against the ultimate proceeds of their case to defray those more immediate expenses. The answer is twofold. One is the rules of professional conduct clearly prohibit a lawyer from ever lending any money to a client. So the answer to the question, can I borrow money from my lawyer, is always going to be no. However, there are many third-party lenders, and actually it's becoming somewhat commonplace for third-party lenders to advance individuals money, to loan them money against the ultimate proceeds of their case. Now, many of these lenders will do so on what's called a contingency basis. In other words, if there is no recovery in the case, the individual that borrowed the money might not have to pay it back. Now, my pat advice to my clients is not to engage in these litigation loans. In my experience, the interest rates and other charges associated with the loan are just prohibitive, and I would suggest to my clients that they not engage in the process. However, I certainly understand and have seen numerous people over the years that simply have no alternative to defray their day-to-day living expenses in the wake of a personal injury situation, accident, or loss, and they have no recourse but to pursue such loans.